Good afternoon, everyone. Hope everyone's well this afternoon. Let's see, it does not appear that courtroom 2 is on yet. Oh, there we go.
We're ready. Good afternoon, Judge.
Good afternoon.
Whenever you're ready, we're going to start with position number 12. Let me make sure. Yes, position number 12, Ms. Reese.
Okay, and you're representing Ms. Reese, Ms. Kim? Okay. Good afternoon, Ms. Reese. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Good afternoon, yes.
Thank you. Ms. Reese, you've been charged in case 23 CR 0058888F with 2 counts of reckless conduct. Who do we have on for pretrial? Mr. Howard.
What number y'all on?
Afternoon. This is position number 12, Mr. Howard.
Give me the name, Judge. I don't have the comment.
Moesha Reese. Miosha Reese, excuse me.
This is her 3rd arrest in the last month. She got an open reckless conduct and a fray.
Good afternoon, Ms. Sari. Is this your case?
Yes, Your Honor. Good afternoon.
You can proceed.
Your Honor, in this case, officers were dispatched out to 681 University Avenue in Atlanta. They were dispatched due to a child walking near the Chevron in this area by himself. The 2 victims in this case, their initials are AR and MR. They're a 2 and a 1-year-old. The defendant left the victims in an unattended apartment where the door was unlocked. One of the victims opened the door and walked out and crossed the street, and that's how he ended up at the Chevron. A security officer told the responding officer that the mother of the child, who is the defendant, was being dropped off near an apartment, and that's when the officer did go back to the apartment. He saw the defendant try to open an unlocked apartment door, and the officer approached her and asked if she had 2 minor children, to which she replied yes. One of the victims was also still in the apartment unattended. Your Honor, in this case, it is being referred to mental health court where bond would be set. All parties, to my understanding, have agreed to that. So we are going to defer to the court regarding the bond.
When is the mental health court scheduled for? Do we know?
Actually, I did receive an email about that. I believe it is tomorrow or the day after tomorrow, but let me double check.
Every Thursday. So, they're kind of like our competency calendar. I don't know if tomorrow is full, but it's every Thursday. So the first available calendar, hopefully it will be tomorrow. But I'm not sure of the case manager for that calendar.
It'll be March 5th, Judge, Thursday. They
Okay.
do it every Thursday.
Okay, perfect. Thank you, Mr. Jordan.
I'm sorry, October 5th.
October 4th?
5th, October 5th, Thursday.
Oh, I'm sorry. Okay, thank you. October 5th. And is DFACS involved in the matter?
Yes, Your Honor.
Okay. Ms. Kim?
Yes.
Is she going to, are you requesting that she get out prior to and come back to the mental health court?
Yes, Your Honor. She has her auntie who's taking care of her 2 children. We do have a phone number and name. I believe that she will be okay.
So, Your Honor, it's our standard practice that surety bond is set. It's my understanding that mental health court is on Thursday. Typically, Judge Kirk likes to speak with the participant and issue the final signature bond. So we will be requesting a surety bond, but I'm more than certain on Thursday she will be released. But it's typically the practice that they go to court in custody and they are released once they had their initial hearing, if you will.
Okay. So for each count, it will be a $2,000 good bond, makes for a total of a $4,000 good bond. Abide by any defects, orders. No drugs, alcohol, or weapons while out on bond.
And Judge, I'm sorry, if we could also request third-party visitation just due to the nature of the case.
If DFAX has third-party visitation, since DFAX is involved, I'm going to let DFAX handle anything that has to do with the minor children. I don't want to put a stipulation on this bond that might conflict with anything that DFAX suggests. So I will just order that
Yes, Judge.
that she abide by any DFAX orders, and they will take care of the visitation, okay?
Thank you, Your Honor.
All right, good luck to you, Ms. Reese.
It was a 4,000 good bond, correct, Judge?
That's correct.
Thank you. Position 16 is a private attorney. That's going to be Mr. Williams.
Judge Morrow, this is Michael Escala. Good afternoon.
Good afternoon, Mr. Lascala. Hope you're well.
I am. Thank you so much.
Good. And this is Nicholas Williams. Good afternoon, Mr. Williams. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. You've been charged in case 23 CR 005891G with simple battery. Is there a history, Mr. Howard?
It's 10th arrest. Last was 2021 failure to appear. Got an open cruelty in the third battery DV out of state court. 2021 cruelty to children, simple battery. 2015 battery DV, cruelty to children conviction. 2013 battery against pregnant female, and a 07 simple battery conviction.
Yes, Ms. Jackson. Ms. Jackson, we can't hear you. I can't hear you. All I can hear is sounds like waves. Mr. Bennett, I need for you to mute your device, please. Ms. Jackson? Okay, you might have to log off and log back on and accept the audio possibly. Mr. Walker, are you able to step in?
I'm here, Your Honor. I can step in. I just need like 20 seconds to pull up the case.
Okay, thank you.
Thank you.
Judge, while Mr. Walker's reviewing that, could you give me that case number one more time, please?
I can. It's 23 CR 005891G.
Great. Okay. Thank you.
You're welcome.
Judge, I also haven't seen a copy of the warrant. This is just a simple assault. Is that the allegation?
It's a
Simple
simple
battery.
battery.
Simple battery. Okay.
And then if Mr. Lascala wants to go first while I'm pulling it up, that's totally fine. Not to relate further.
I know very little about this case other than my client was
Okay.
pulled over in DeKalb County, spent a good amount of time in the DeKalb County jail before being transferred over. He does have an open case. The one open case he has is in Judge Mather. I know this case is going to trail that. It's also been assigned to Judge Mather. I do represent him on the other open case.
Does he have a bond on the other open case?
He does. He's out on bond. He's already been processed on that, and we're just waiting for an arraignment date.
Was it a surety bond or a signature bond?
I want to say it was a good bond, but Judge, I don't have the file in front of me. I'm still downtown.
Okay.
I've known Mr. Walker a long time. I'm sure he's going to make a very reasonable offer.
Karen, are you able to hear me?
Yes, I can hear you now.
Okay.
I can't see you though, Ms. Jackson.
It
I'm not
looks like
sure
your
what's going
video
on.
is on. Something's probably blocking your camera because it looks like your video is turned on.
I don't know. I was having issues with my camera on yesterday. Your Honor, if you want me just to have this handle this case and then I can figure out my camera.
Okay.
This is the next-
If you're ready to handle it, go ahead, Ms. Jackson.
Yes, Your Honor. It's my understanding that this incident took place back in May of this year, May the 16th. On May the 18th, the victim in this case, Shamaya Hill, came to the precinct and requested that the police officers escort her back to her home in order to retrieve some of her belongings because she did not feel safe going home. 2 days prior to her coming to the precinct, she indicated that her boyfriend, the defendant, was watching their children while she went to go see her lawyer. She said that the appointment lasted longer than expected and it caused the defendant to miss out on his other child's birthday party. The defendant was very upset and a physical altercation ensued. Ms. Hill indicated that she was pulled by the hair, slapped in the face, pushed on the ground, and kicked in the back. In an attempt to defend herself, she struck the defendant in the face with her phone, and the defendant continued to hit her in the face. All of this took place in front of their very young children. The victim eventually left and went to her mother's home. Based on the 10 cycles that the defendant has, Your Honor, we'd be asking for a $2,000 surety bond, no further contact with victim Shamaya Hill, 1 anger awareness class, and no alcohol, drugs, or weapons.
Okay, Mr. LaScala? You're on mute. You're on mute, Michael.
Sorry about that, Judge. I apologize.
Oh, that's fine. Go ahead.
Judge, I think under the circumstances, the $2,000 is reasonable. The anger management, I believe that's just standard. I don't believe any allegation of drugs or alcohol were alleged, so I don't believe that's a condition that needs to be in place. But I think all the other conditions are reasonable.
Okay. It will be a $2,000 good bond, no further contact with Ms. Hill. As a standard condition of this court is to no drugs, alcohol, or weapons while out on bond. Given that he's got that other case, I'm not going to require anything else at this point in time.
Okay.
Okay, anything further on Mr. Williams?
No, thank you so much, Judge.
All right, have a good afternoon.
Great to see everyone. Take care.
Bye-bye. Who do we have next?
Next, Judge, we can do the jail court's iPhone
Okay,
medical.
and who do we have in medical?
That's position number 2.
Okay, good afternoon, Ms. Benson. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video. Do you agree to have your case heard by video? Do you agree to have your case heard by video?
What you said?
We're doing this by video. Is that okay with you?
Yeah.
Okay, you've been charged in case 23 CR 0058887A with willful obstruction of a law enforcement officer and reckless conduct. Is there a history, Mr. Howard?
Second arrest, last arrest was in March. Theft by receiving, obstruction, giving false name. That's open in Superior Court.
Okay, good afternoon, Ms. Memini.
Good afternoon, Your Honor. This incident happened September 14th of this year at 54 Peachtree Street Southwest. On that day, officers had received a call about a person shot at that location. Once they arrived, they learned from Officer Rudger from the Martis Police Department that he was patrolling when he heard the shot, and he immediately turned to where the gunshot came from. And then that's where he saw one black male with his arm extended holding a firearm. And he also saw 5 other suspects near that male, and they started running, and one was the defendant. He gave a lookout on the radio and assisted other MARTA officers, and they began to flee from the officers. And that's when the officer was chasing the defendant to the intersection of Mitchell Street and Richard B. Russell Plaza. And at that time, both of the suspects, including the defendant, jumped off the Russell B. Plaza Bridge onto the gravel. That was somewhere near a 50-foot drop. They both sustained injuries, and 2 firearms were recovered from the scene along the route that both parties were running. And it looks like defendant had a privately manufactured firearm, AKA, also known as a ghost gun. Considering the fact, Your Honor, for count 1, the state is asking for a $1,500 surety bond. For count 2, a $15,000 surety bond. Stay away from that 54 Peachtree Street Southwest. No alcohol, guns, drugs, or weapons, and to present all of his firearms to the Fulton County Sheriff's Department, Your Honor.
Afternoon, Ms. Abden.
Good afternoon, Your Honor. My client is 17 years old. He has lived in Georgia for the past 3 months. He recently moved here. His dad lives here, and his sister, who's 22 years old. So he does have ties to the community, although he did just move here. It's my understanding he's enrolled in high school in Atlanta. He goes to Atlanta Virtual Academy. He's a senior. He's also gainfully employed. He's working at Wendy's. And I did speak with his mother, who lives out of state, and I just called his dad. I wasn't able to fully speak with him. He confirmed that he does live with him. If Your Honor would be willing to give him a signature bond, he would be able to sign him out. Your Honor, this is just his second arrest. He's very young. And so I am requesting a signature bond and that he be allowed to return to school and get back to his job. And the longer he remains in jail, the more likely it is he will lose that job. And that is all.
What's his father's name?
Marcus Benson.
Where is he in school?
Atlanta, it's virtual, Your Honor. So it's called Atlanta Virtual Academy, and he's a senior right now.
And Your Honor, he also has 2 open cases.
He already out on pretrial anyway.
Do you have the name of the person that he was, the person that was with him, Ms. Nimini?
Yes, Your Honor. His name is Tremon Palmer.
Spell that for me, please.
Tremon Palmer, Palmer.
Given that he has pending charges or allegations for the willful obstruction, it's going to be a $500 good bond. For the reckless conduct, it's going to be a $1,500 good bond. He is to stay away from 54 Peachtree Street. He is to have no further contact with Tremon Parker. He is to have a curfew of 9. He's to be in by 9 p.m. He has to stay in until 6 a.m. No drugs, alcohol, or weapons while out on bond. Okay, good luck to you, Mr. Benson.
Thank you, Your Honor.
You said, what's the bond?
It's a $2,000 surety bond.
And Mr. Benson, I'm gonna call your dad back and let him know.
And that's 10%, right?
Miss Abner will speak with you after court today.
All right.
Okay. Who do we have next?
Position 11, offered.
Good afternoon, Mr. Offord. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video? Can you hear me, Mr. Offord?
Yes.
And you agree to have your case heard by video?
Say it again.
Yes.
Okay, thank you. You've been charged in case 23 CR 005897D with violating the Family Violence Protective Order and willful obstruction of law enforcement officers. Is there a history, Mr. Howard?
2014 assault. It was dismissed in New Jersey. Just his second arrest.
Okay. Ms. Sorry.
Yes, Judge. This incident took place at 556 Cairo, that's Cairo Street in Atlanta. The victim in this case is Marvin Bennett, common spelling. He sought and was granted a family violence protective order back in September of this year. That was September 6th. The defendant, he admitted that he knew of this protective order, but he still went to the incident location. And when officers, of course, were on the scene, they attempted to arrest the defendant for the violation and he resisted, I'm sorry. We are still looking into this matter, Your Honor, but the victim is on the call. We did speak with him and he stated that the defendant has threatened him and tried to forcefully come into his home despite the protective order. Currently, there is a $10,000 surety bond set. That's $5,000 on each count. We're asking for it to remain as set, or if Your Honor would keep the $5,000 surety on the violation of the Family Violence Protective Order and issue a $1,000 surety on the obstruction, as well as a stay away from the incident location, no contact with the victim, to abide by the Family Violence Protective Order, and no drugs, alcohol, or weapons.
If Mr. Marvin Bennett is on the line and wishes to address the court, I see you there, Mr. Bennett. If you would like to address the court, I need for you to unmute yourself and I'll have to swear you in. But you are not required to address the court if you don't choose to. Mr. Bennett, can you hear me? Mr. Bennett, I'm not sure if Mr. Bennett does not want to address the court or if he cannot hear me.
He's muted.
Well, he should be able to respond to I don't know if he hears me or not. Ms. Kim?
Yes, Your Honor. My client is actually, I try to find the family protective order at Odyssey, but I could not find it. So we would like to know if there was a case number. And my client says there was a dispossessory action hearing set on October 19, 2023, 9:30 a.m. That's where this eviction process and all the things gonna be handled. And we don't think family violence was actually involved. We just thought there was a dispossessory action. My client has 3 minor children that he's taking care of, Your Honor, and he has been working really hard, almost 2 jobs every day. All he does is working, housekeeping, kitchen, hospitality, and he has to pay child support every month for his 3 minor children. So we would like to request for signature on bond for this, and this can be handled outside of criminal court. And it should be more like civil matter, Your Honor. Thank you.
And Judge, I do have that temporary protective order case number.
Okay, if you would like to give that to Ms. Kim.
Yes. Was there actually a hearing and there was an order?
Um,
Is the presence there?
there's an order. I'll just send it to you.
Thank you very much. I appreciate it.
And what's the date of that order?
I only have the case number. I'm sorry, Judge.
Okay.
It was September 26th, I'm being told.
Okay.
Oh, he's recommended, Your Honor. We would like to request for signature on bond. Thanks.
All right. For the violating of the protective order, $4,000 signature bond through pretrial per the judge. For the obstruction, $1,000 signature bond through pretrial makes for a total of a $5,000 signature bond through pretrial. No further contact with Marvin Bennett. Stay away from the Cairo Street address. I'm not, does he need to go back there with law enforcement, Ms. Kim? He's not going to be able to go back otherwise.
Correct. One time.
One-time escort with law enforcement to retrieve any belongings that he might have there. No drugs, alcohol, weapons while out on bond. No contact, Mr. Offit, means absolutely no contact. No phone contact, no personal contact, no email contact, no social media contact. You can have no contact with Mr. Bennett whatsoever unless it's through a legal proceeding, and you can go back to that location only one time with law enforcement to retrieve your belongings from there. Good luck to you, sir.
Thank you.
Position 17, Wilson.
Good afternoon, Mr. Wilson. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Good afternoon, Your Honor. Yes, I do.
Yes. Good afternoon, Mr. Wilson. You've been charged in case 23 CR 005890C with failure to have your license on your person, a seatbelt violation, and driving while your license was suspended or revoked. Is there a history, Mr. Howard?
He got over 20. Last arrest was a couple of days ago out of Gwinnett, giving false name, possession of marijuana with intent. Got an obstruction, driving without a valid license that's open in Clayton County. 2023, unauthorized use of a vehicle that was in another state. 2022 bench warrant. 2022 no permit. And a 2017 no permit. That's it.
Okay. Who's presenting for the state?
Your Honor, it's me, Attorney Jackson, and I'm still unable to get my camera to work. So if the court would just bear with me. The offense took place in April the 30th in the year of 2022. On April the 30th, the Accident Investigations Unit was dispatched to 220 Northside Drive in reference to a fatal person struck by motor vehicle collision. The initial investigation showed that a group of people were crossing the Northside Drive at the intersection of Northside Drive and Thurman Street. They were crossing in the crosswalk, but the do not walk light was on. The victim was struck by the black BMW with a Tennessee tag, and the driver, which was the defendant, remained on the scene and provided a written statement to the investigation unit. The defendant provided a picture of his temporary Washington, D.C. license. However, it was expired. His Georgia license was also suspended. And at the time of the crash, Mr. Wilson was not wearing a seatbelt. Based on his history, we are asking for a $2,000 signature bond pretrial through pretrial services and no driving without a valid license.
Okay, if okay with you, Ms. Kim, it's going to be a $250 signature bond for the failure to have license on person, a $250 signature bond for the seatbelt violation, a $500 signature bond for the driving while license suspended or revoked. That's a total of $1,000 signature bond. It's going to go through the jail, no driving without a valid license, and no drugs, alcohol, or weapons while out on bond. Does that suit you, Ms. Kim?
Yes, Your Honor.
All right, good luck to you, Mr. Wilson.
Thank you, Your Honor.
You're welcome.
Position 6, Edmonds.
Good afternoon, Mr. Edmonds. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Edmonds, you've been charged in case 23 CR 00589 with certain acts on a bus rail station prohibited. 1, 2, 3 counts of willful obstruction of a law enforcement officer and giving false information to law enforcement officer. Is there a history, Mr. Howard?
28 total. Last arrest was 2021 trespass. Let's open the state court. 2021 failure to appear. 2019 battery DV. 2017 simple battery DV conviction. 2012 trespass no-low. He got an open burglary smash and grab in Superior Court. I don't know what his bond was today.
Okay, Ms. Nemini?
Yes, Your Honor. This incident happened yesterday at 680 Lee Street at the West End MARTA station. Officers observed the defendant drinking a Four Loko. When he was approached, he provided officers with the wrong name, saying that he was Demetrius Ross. When the officers found out that he was actually who he is, Mr. Dante Edmonds, they attempted to detain and arrest him, and that's when he fled from 4 officers. He resisted arrest by tucking in his arms, ignored verbal commands to stop, and he had to be sprayed with OC, which I'm not entirely sure what that is, but we're gonna keep it going to gain compliance, Your Honor. So bond is currently set at Bond is currently at 2,500 surety for each count. The state is asking to lower it to for count 1, 1,000, for counts 2 through 4, 500 each, but keep it for counts 2 through 4, 500 each for surety, which comes up to I can't do my math today, Your Honor. 3,000, I think, 3,000.
Okay. Ms. Ablin, if agreeable with you, it's going to be a $500 signature bond through the jail on each count, which makes it a total of a $2,500 signature bond through the jail. Stay away from the West End MARTA station. No drugs, alcohol, or weapons while out on bond. Does that suit you?
Yes, sir.
Yes, thank you, Your Honor.
Okay, good luck to you, Mr. Edmonds. You can't go back to that West End MARTA station for now, okay?
Yes, sir.
All right, good luck to you, sir.
Position 15, Triplet.
Good afternoon, Mr. Triplet. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
I do.
Thank you. Mr. Triplet, you've been charged in case 23 CR 005892G with theft by taking. Is there a history, Mr. Howard?
This is 9th arrest. 2013 ag stalking first offender. 2012 theft by taking dead doctor. That's it.
Who's presenting for the state? Who's presenting for Ms. Sori?
No, Judge, I was gonna ask, what's the position number?
Number 16. I'm sorry,
Yeah.
number 15, Mr. Triplet.
Are you able to hear me, Your Honor?
Okay, yes, go, Ms. Jackson.
Okay. This incident took place on October the 2nd. The officers were dispatched to Piedmont Hospital. They spoke with the security manager, who indicated that the defendant was observed through surveillance cameras removing building materials from the work site on September the 25th, 2023. The defendant cooperated with police investigation by admitting to removing and returning the stolen items. The rightful owner of the materials, Triad Drywall LLC, wanted to press charges, so the defendant was arrested and charged. The state is asking for a $1,000 signature bond through pretrial services and a stay away from 1968 Peachtree Street in Atlanta.
If agreeable with you, Ms. Kim, it'll be $1,000 signature bond through the jail. Stay away from 1968 Peachtree Street, and no drugs, alcohol, or weapons while out on bonds. That suit you?
Yes, Your Honor.
All right, good luck to you, Mr. Triplett.
Thank you.
Position 13, Robinson.
Good afternoon, Mr. Robinson. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank
Good
you. Good afternoon, sir. Mr. Robinson, you've been charged in case 23 CR 005898B with battery family violence, 2 counts. Is there a history, Mr. Howard?
37 total. A resident of Charlotte, according to the booking. 2022 simple breaking and entering a motor vehicle. On probation, possession of a firearm by convicted felon. Got a 2022 probation. 2022 kidnapping, assault on female. Assault with a deadly weapon, breaking and entering, communicating threats. 2019 possession of a firearm by convicted felon conviction. 2017 simple assault conviction. And an 09 robbery conviction. That's it.
Ms. Sorry.
Yes, Judge. This incident took place at Dean's Midtown. That's located at 1184 Spring Street in Atlanta. Your Honor, an employee actually called the police and advised that he saw a man who was the defendant beating up a woman. And that woman was LaShawnette, LASHAUNET, last name Robinson. The employee did say he saw this occurring in the rear of a parking lot. When officers arrived, they saw the victim sitting on the ground with her clothes torn and visibly upset. When asked what happened, the victim first stated that nothing happened, and later she stated that she and the defendant were in a verbal argument when he got physical by punching and kicking her. Your Honor, the defendant also beat her with a belt. So we do have these 2 charges separated, one for the punching and the kicking the victim, and the second charge is beating her with a belt. This victim did sustain a busted lip, bruises, and scratches all over her body. As you've heard from pretrial, this defendant is a violent offender. I do believe that the 2 are in a relationship, so he does present a risk of intimidating the victim. We would also argue that there hasn't been sufficient cooling off period, as this did occur yesterday. And this defendant does not seem to have ties to the community due to being an out-of-state resident. Your Honor, we are asking for a $10,000 surety bond on this case. That's $5,000 on each count, no contact with the victim, a stay away from the incident location, 1-day anger awareness, and no drugs, alcohol, or weapons.
Okay, I see Ms. LaShawnette Robinson on the line. Ms. Robinson, if you wish to address the court, now is your opportunity. You, of course, do not have to address the court, but if you wish to address the court, you'll have to unmute yourself, activate your camera, and I'll have to swear you in. Does not appear that she wishes to.
I'm trying to come on camera. Hello?
Okay, yes, Ms. Robinson, can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, what would you like to tell the court?
I would like to tell the court that me and the victim went to, me and the defendant went to a club called Trapezes, which I still have on the wristband. So the marks I sustained came from that incident at the club. It's a sex club. I'm not afraid of the victim. I would like to have contact with Mr. Robinson.
Okay, so Ms. Story, Ms. Sori tells me that, that someone witnessed, you being beaten with a belt. Did that happen?
No, sir.
Ms. Sori also told me
When-
that someone witnessed, Mr. Robinson, kicking and punching you. Did that happen?
No, sir.
Have you ever had any, issues with, Mr. Robinson being violent?
No, sir.
Ms. Sori, do you have any questions?
Excuse me.
No
Okay.
questions at this time, Your Honor. We would just ask you to keep in mind the cycle of violence and the fact that the victim may still be in that cycle.
Okay, Ms. Kim? Yeah, Ms. Robinson, yes.
No, we don't live together. We do share children together, but we don't live together. We're not in a relationship.
How many children? How many children do you have together?
2,
What are their ages?
4 and 6.
All
So
right.
he moved up this way, so I was just visiting.
Okay, so you don't live in Georgia.
No, sir.
Okay. All right, thank you, ma'am. Ms. Kim?
Yes, Miss Robinson, may I please ask you one question? Were you drunken at the night? This is
I had some drink.
no further question, Your Honor. My client says that he is denying the allegation. I'm kind of shocked because what my client told me and the warrant is completely different. He says that it was his birthday. Of course, Miss Robinson came to celebrate. He's a sole custody. He has a sole custody of 2 children. So that way, since his children are here, she wanted to hang out with her children and him and celebrate the birthday. But that's the date that she was drunken, and then people misunderstood about loud noise, and he did not even though the officer was going to arrest her, he did not want her to be arrested because he wanted to make sure that she spends time with her 2 kids who are only 4 and 6 years old. We would like to request for signature on bond for him. He's gainfully employed at YBE Trucking Company. He completed GED, even though there were some histories in the behind. He's totally turned around and became a different person, making a really good money. And he's been here in Georgia for the last 3 years. This is his full-time place. Your Honor, we would like to request for signature on bond. We are okay with the no further contact since they don't live together. And considering the fact that my client has full custody of those 2 children, I think it is necessary to have kids with him. And also, Your Honor, I guess that's about it. Thank you.
Ms. Sorry, did you tell me that that a third-party independent witness reported these allegations to a police officer?
Yes, Judge, a third party, which would be an employee of the incident location, actually called the police. So this was by an independent party. And Judge, I would like to point out, it does appear that the victim has a swollen lip at the moment.
All right. It will be a $2,500 good bond for each charge, makes for a total of a $5,000 good bond. No further contact at this point in time with Ms. Robinson. Stay away from the Dean's Midtown location. Third-party transfer of any minor children, and no drugs, alcohol, or weapons while out on bond. Good luck to both of you.
Thank you, Your Honor.
Position 8, Hatcher.
Good afternoon, Mr. Hatcher. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. Mr. Hatcher, you've been charged in case 23 CR 0058885J with theft by shoplifting, terroristic threats and acts, and simple assault. Is there a history, Mr. Howard?
His ninth arrest. He was arrested on the 8th of last month for obstruction, 2 counts, and a simple battery. Pled no load to that out of Clayton County. Got a arrest for public transit prohibited acts out of DeKalb, aggravated battery as well, theft by shoplifting, 2023 failure to appear ag assault, and a 2015 assault with dangerous weapon. That's it.
Ms. Sorry?
Yes, Your Honor. This incident took place at Home Depot located at 2525 Piedmont Road in Atlanta. Officers were dispatched in regards to a weapons call. The defendant was seen by the victim, whose name is Darius Mitchell. That's Darius, Mitchell, common spelling. This victim is actually a loss prevention officer, and he saw the defendant take a $30 broom and walk past all points of sale. When the victim approached the defendant and told him to return the broom, the defendant refused. At that point, the victim took the broom from the defendant and walked back in the store. The defendant then went in the store, approached the victim with his fist balled, and threatened to beat up and shoot the victim. Another loss prevention officer was there on duty and overheard these threats, and that's when they called the police. When police arrived, the defendant did admit to officers that he took the broom, but said that he threatened to get the victim shot. As we've heard from pretrial, this defendant does have a violent history, that ag assault just 3 months ago out of DeKalb. He does present a risk of reoffending. He's been arrested multiple times this year, and he does present a risk of flight due to that FTA just in June of this year. The state is recommending a $15,000 surety bond. That's $1,500 on a theft by shoplifting, $12,000 on the terroristic threat, and $1,500 on the simple assault, with conditions of no contact with the victim, a stay away, 1-day anger awareness, and no drugs, alcohol, or weapons.
Ms. Abden?
Thank you, Your Honor. My client is 23 years old. He moved to Atlanta about 2.5 years ago. He recently fell on hard times. He is residentially insecure. He tells me that he's living out of his van. However, he is still gainfully employed. He's working at Chipotle. He's been working there for 1.5 months, and the longer he remains in jail, Your Honor, the more likely it is he will lose his job. This job is all he has at this time, Your Honor, and I'm asking you to take his indigency, earnings, and income into consideration when setting bond today. I did connect him with a social worker who's going to help him out with housing. And I do understand the state and the court's concern about the previous FTA, but that is due to his residential insecurity, and we're hoping that a social worker can help him out with that. I also have a good email address for him, and he does qualify for public defender services, so we will be representing him in this case after today. He does deny the allegations, Your Honor. He tells me he doesn't own a gun. He was not armed at the time. The broom in question is $30, as the state stated. And due to his indigency and his circumstances, Your Honor, I am requesting a signature bond for my client, and he would agree to a stay away and a no further contact with the complaining witness if that is necessary.
All right, for the theft by shoplifting, a $500 good bond. For the terroristic threats, a $1,000 good bond. Simple assault, $500 good bond, total of a $2,000 good bond. Stay away from the Home Depot on Piedmont Road. No further contact with Darius Mitchell. No drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Hatcher.
Position 5, Davis.
Good afternoon, Mr. Davis. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Good afternoon, yes, sir.
Thank you. Mr. Davis, you've been charged in case 23 CR 005899Y with battery family violence. Is there a history, Mr. Howard?
This 10th arrest. Last arrest was last month, probation. Got an open criminal damage to property, ag assault, simple battery out of Superior Court. It's 22 CP 210319. 2020 battery DV, 2020 simple battery DV conviction, 2016 simple battery conviction. That's it.
Ms. Nemini?
Sorry. Yes, Your Honor, this incident happened April 30th of this year at 62 Hartwell Road. Officers arrived at the location around 4 a.m. in the morning. They were advised by Ms. Shatiria Newsom, and I would like to sound for her if she's on the Zoom call today, that her and her boyfriend, which is the defendant, that had struck her with a belt, leaving visible injuries. The parties share a child together and they do live together. And I want Your Honor to note that the 2017 case is the same victim, Ms. Newsom. The 2020 case is the same victim. The 2011 case is the same victim. And the felony case in Fulton County currently is the same victim, which he was ordered to stay away from the victim as she was trying to move out of the home. So considering those facts, Your Honor, the state is asking for an $8,000 cash bond. No alcohol, drugs, guns, or weapons, to stay away from Ms. Shatiria Newsom in a FVIP course. And that's it, Your Honor.
If Ms. Shatiria Newsom is on the line and wishes to address the court, now is your opportunity to do so. Ms. Abden?
Thank you, Your Honor. My client is 32 years old. He was born in Atlanta, has lived here his whole life. He has his GED. He's a father to 2 minor children, one of which he has with the complaining witness. He's responsible for school drop-off and watching the child until the complaining witness returns home. She works late. It's my understanding from both my client and the complaining witness, they do not live together anymore at that address. They're living separately, but they are still co-parenting, and the child stays with my client part-time. He did recently lose his job. He was working in construction. He's currently looking for work. It's my understanding that he plans to work at a temp agency doing construction work in the meantime until he finds a new job. He has been in jail for 20 days so far, Your Honor, on a probation violation. The longer he remains in jail, the less likely it is that he will find employment and be able to take care of his child. I did speak with the complaining witness. She did state that she's not afraid of him and would like to continue having contact with him for the purpose of co-parenting, and that she stated that his presence is essential to help with the child care. My client would agree to a no further violent contact or a no further contact if that is necessary, so long as there's a third party transfer to help them out with the child. And I am requesting a signature bond, Your Honor, and objecting to the family violence intervention course. This is not his sentencing today, Your Honor. He does maintain his innocence until proven guilty.
And Your Honor, I just want to put it on record that, you know, he has multiple probation violations and a history of not appearing for his cases. And considering, and we are going to object to a signature bond, considering that there are 4 cases on record, and I wasn't able to find the disposition for Forest Park of a battery family violence involving the same victim. I understand the victim, Ms. Newsom, says she wants him in her life, but based on the circumstances and based on the history, we would sound for the third party transfer, but we do not want a signature bond at all. And we don't want them to have any further contact, Your Honor.
And Your Honor, as I stated, I would not object to a no further contact so long as he can continue helping with the co-parenting. As I stated, his presence is essential for that. And setting a bond for him at all, Your Honor, at this time is going to be no bond at all. He's not working. He can't afford anything at all. And the longer he stays in jail, you know, the complaining witness is struggling to deal with the child care without him there. And I'm asking Your Honor to take that into consideration. I do understand the state's concern and the history of violence between the parties. And so a no further contact, I believe, would resolve that, especially considering that they do not reside together at this time. And if all of those cases are open, Your Honor, he's not
They're
been.
not open.
They're not? Okay.
No, there's
I
four.
I misunderstood you.
4 conviction. There's one open case for ag assault that recently happened. 4 convictions with the same victim.
Understood. Well, as I've stated, although there is a history, Your Honor, my client is going to be represented by us. And so we do have a current address for him. He will return to court. He does understand his obligation to return to court. And so I'm asking Your Honor to please allow him to return home and be able to take care of his child. And he will abide by any conditions that the court finds necessary. And that is all at this time.
It will be a $3,000 good bond, no further contact with Ms. Newsome, stay away from the Hartwell Road address. There'll be third-party transfer of any minor children for visitation or transfer to school, no drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Davis.
Thank you, Your Honor.
Position 7.
Good afternoon, Mr. Yanwa. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You've been charged in case 23 CR 005894F with willful obstruction of a law enforcement officer and criminal trespass. Is there a history, Mr. Howard?
$58 total. Last arrest was last month. Shoplifting. That's open out of the cab. He's on probation for what I sent you in the chat. He has a 2023 probation violation from this year. 2017 failure to appear. 2017 trespass nolo, and a history out of Tennessee. That's it.
Ms. Nemini?
Yes, Your Honor. This incident happened yesterday at the Oakland City MARTA station around 6 p.m. Officers were walking patrol when they observed the defendant smoking a brown paper cigar containing what is suspected to be weed. In an attempt to approach the defendant, he got up and walked away towards the end platform of the MARTA station. In an effort to elude officers. He was provided verbal commands to stop walking, in which he continued to walk away. And then he began to jog towards an unauthorized gate leading to the rail tracks. He ran onto the rail tracks, which caused a pause in the MARTA rail system because that's where the rail train passes by through. And once officers were able to catch him, he did attempt to resist arrest. Based on the facts, Your Honor, the state is asking for a $2,000 surety bond, asks stay away from the Oakland MARTA station, no alcohol, drugs, guns, or weapons, Your Honor.
Ms. Abden?
Thank you, Your Honor. My client is 41 years old. He was born in Atlanta, has lived in Atlanta his whole life. He has his high school diploma. He's gainfully employed. He works at Fulton County Industrial Warehouse, where he does maintenance work. We do have a current address for him. He understands his obligation to return to court. And so he's not a flight risk at this time. And he would agree to a stay away. I am requesting a signature bond for my client, Your Honor. He would not be able to afford any bond at all at this time. And so setting a bond for him would mean no bond at all.
For each count, it'll be $1,000 signature bond through the jail, totaling $2,000 signature bond through the jail. Stay away from the Oakland MARTA station. No drugs, alcohol, or weapons while out on bond. Good luck to you, sir.
Judge, I'm sorry, what's the total?
$2,000 signature bond through the jail. 1 and 1.
Oh, 1 and 1, okay. Thank you. Position number 4, Mr. Cook. I do have a quick announcement, Judge, before,
Okay.
for Mr. Holloway. He was on the pull sheet, but he's not on the calendar. I wanted to find out his disposition.
What was the name?
Holloway.
Mr. Holloway, first name is.
No, Holloway. Let me make sure, because there was a few.
He was also in the pull sheet yesterday.
Mhm.
Not on
I
the
want to say it was
calendar.
part of a felony case.
Mhm.
It might even had a DA number. Is that Mr. Jordan? Is that the one we emailed about earlier? Yeah, he has a DA number 23 DA 06662. So it's my understanding that it's a felony case that needs to be addressed in Superior Court.
There's a family violence,
I
which is.
know, and I'm guessing because he also has an aggravated assault. I don't know if it's with the same victim, but they've assigned a DA number to it. So that was my understanding.
I think the one that we had emailed back and forth was Camp Loan, CAMPLONE.
Yes, and that was another case that started out as a felony case, and they took out additional misdemeanor warrants, but it's from the same incident as the felony case.
Mhm.
So Superior Court will have to address that. She has a felony theft by taking.
Okay,
Long story short, she stole a car. She also was drunk while she was driving it. So the felony theft by taking was stealing the car, and then the DUI, which is the misdemeanor. But that's all from the same fact pattern. So they'll have to assign that CP number to those misdemeanor warrants as well.
okay. Thank you.
Right, who do we have next?
Hey, Ms. Kim, we're trying to call you. Position number 7. So what's the disposition for Mr. Holloway?
Because I understand there is a Superior Court case, but
Yeah, he has a DA number assigned to that charge.
Okay, that's confirmed, so he's not supposed to
Yeah,
be
no,
here
I
today?
can read did you get the DA number that I read?
No, do you mind giving it to me again?
23 DA 06662.
Thank you.
Who do we have?
Hey, Ms. Kim, we're trying to call you. Ms. Kim,
Yes, I'm trying to answer it, but it keeps dying. Okay. Can you call me on my office number?
Call her on the office number.
404-1122, please.
What number, Ms. Kim? I didn't hear you, I'm sorry.
404-612-1122.
Okay, he's calling that now.
Thank you.
You're welcome. Position 4, Mr. Cook.
Good afternoon, Mr. Cook. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir. Good afternoon, Judge Morrow.
Good afternoon, Mr. Cook. You've been charged in case 23 CR 005893F with tampering with evidence and willful obstruction of a law enforcement officer. Is there a history, Mr. Howard?
Third arrest, 2022, window tint. He got an open case in state court carrying a weapon without a license. 22 CR 006-994F. Possession of open alcohol container, obstruction, and a PI charge. That's open in Superior Court. 22 CP 208975.
Okay, Ms. Nemini?
Yes, Your Honor. This incident happened at 44890 Yates Road, September 30th of this year. This is originally his father's case, but then he jumped into the everything shortly after. Officers were dispatched to that location due to a discharge of a firearm call. They made contact with the victims, Miss Allison Eccles and Cassandra Eccles, who advised officers that they were backing into the driveway and they accidentally drove over the owner's grass. The old man, which is the defendant's father, Mr. Antonio Koch, confronted the women and yelled at them slurs, saying, "B word, why are you on my grass?" They told him to chill out. The glass was dead. It's not that serious. He responded, "I will show you," and pointed a black gun towards the vehicle and shot at the tires. 3 people were in the vehicle. There were 3 passengers. 2 of them were minors. While on the scene, officers did come to that location, and that's when defendant comes in. Defendant told the officers that Mr. Antonio Koch was his father, and as officers were conducting the investigation, that's when defendant located the shell casings that his father had shot into the vehicle, and then he put it in his pocket, and an officer observed him doing that, and he attempted to flee. And as once he was captured, he was resisting arrest, and during the arrest, he threw the shell in order to prevent the officers from finding the casings. Considering that it does deal with gun charges and he was trying to aid his father, Your Honor, the state is asking for count 1, 15,000, count 2, 1K surety, which is, I think, is currently at 16,000 currently, but the state is asking to keep it. And that's it, Your Honor.
Ms. Abden?
Your Honor, my client is 22 years old. He was born in Atlanta, has lived here his whole life. He graduated from high school and then he went on to the military where he was an aviation electrician and he was honorably discharged. He's gainfully employed. He's working at a clothing warehouse called Stitch Fix. He was just onboarded on Friday and he was supposed to come back on Monday, yesterday, for his first day of work, but he was arrested due to this incident. And so he's afraid that he doesn't have a job anymore, Your Honor. He's been speaking with his sister who does work there as well. And, they stated if he's not able to come back soon, he will lose his job. So I am asking Your Honor to take that into consideration. He is living with his girlfriend at the moment. At a different address. That the incident address is his father's home. He was just visiting, and he is the primary breadwinner for his girlfriend and her child, who is a minor. He is responsible for the bills and the rent, and which was due on the 1st of the month, Your Honor, and he was not able to pay that as he has been in jail since the 30th. He is financially responsible for everyone in the household, and so I am asking Your Honor to take that into consideration. He firmly denies these allegations, Your Honor. He, without going too much into the facts, he stated that he was told that he should go get medication for his dad, who was about to be arrested, and all of this had transpired, and he denies ever tampering with any evidence at all. He's a good kid. He's just trying to, provide for his girlfriend's child, and he would really like to be released, Your Honor, to ensure that he still has a job. And so I am asking Your Honor for a signature bond, and if Your Honor is not inclined for a reduced bond, the $16,000 amount is extremely high, and he would not be able to afford that. And if Your Honor is not inclined to give him a signature bond, I am requesting a low bond of $1,000.
Your Honor, I just want to mention that his father is a convicted felon who is not allowed to have guns with him. So considering the fact that he did know that what was going on and why his father was being arrested, it does seem like he was attempting to aid his father who is not supposed to have a gun, and he fired a gun into a vehicle with passengers inside. Considering he doesn't really have any criminal history.
Your Honor, we're talking about my client. His father's actions are separate from his, they'll have a trial about that and the opportunity to present evidence against his father. As far as my client goes, he was just there visiting his father. He was unaware of the situation.
I understand. I'm going to give you the signature bond,
Thank you, Your
but
Honor.
it looks like we've lost courtroom 2, so I can't do anything until they come back. So I wanted your client to at least hear your argument, but I didn't want to interrupt you.
Thank
We
you.
lost them, I think, a minute or two ago. But I'm sorry, I didn't mean to interrupt you, but I just wanted to let you know that we don't have courtroom 2 on the line.
No worries. I appreciate it, Your Honor.
Okay. Mr. Jordan, do we know what happened to courtroom 2? I guess they lost their connection.
Yeah, I'm not sure, Judge. They may have lost connection. I'll give them a call and see.
Okay. All right, we'll have to be in recess until courtroom 2 rejoins us. And at which time I'll make my bond announcement.
Dojiel is logging on right now, Your Honor. They were disconnected and they're coming in right now.
Okay, thank you, Ms. Kim.
All right, Judge, we had got disconnected.
Okay. Let's see, Mr. Cook, the bond will be for the tampering with evidence, a $4,000 signature bond through the jail. For the obstruction, $1,000 signature bond through the jail, makes for a total of a $5,000 signature bond through the jail. No drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Cook.
Thank you.
You're
Thank
welcome.
you, Your Honor.
Position 1, Beasley.
Good afternoon, Mr. Beasley. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video? Thank you. Mr. Beasley, you've been charged in case 23 CR 0058884E with simple battery family violence. Is there a history, Mr. Howard?
6 total. Last arrest was last year. Battery DV out of Douglas County. That appears to be open. 2016 cruelty in the second dismissed.
Yes, Ms. Nemini.
Yes, Your Honor, this incident happened July 29th of this year at 235 Fireside Way, Fairburn. Officers made contact with the victim, Ms. Tamika, Temeka, Tooks, Tookes, the girlfriend who also resides at that same residence. She advised officers that the defendant had pushed her into the tub shower area of the bathroom, turned on the shower, causing her to get soaked with water after a verbal argument had ensued. Considering the state was able to speak to Ms. Tooks, she states that they are married now. They live together at the incident location. They do share 4 children. She confirmed the events in the warrant, but states that she is not in fear of the defendant. She says that the argument began based on them both drinking that night, and he hasn't been violent with her since. The incident happened in 2022, but this incident happened July of 2023. Based on the facts, Your Honor, the state is asking for a 5,000 surety bond. Stay away from that location, 235 Fireside Way, Fairburn Road. No further contact with Ms. Tamika Tooks. No alcohol, drugs, guns, or weapons, Your Honor. And I would like to sound for Ms. Tooks if she's here. And I just wanted on record that from the 6 cycles he does have, we have a simple assault, a simple battery, cruelty to children, battery family violence, simple battery family violence. So out of the 6, 5 of them are battery.
Okay, Ms. Tooks, if you're on the line and wish to address the court, now is your opportunity to do so. There you go. I need for you to unmute yourself. I'm not sure what type of device you're on, Ms. Tooks, but you might need to go to the bottom of it. There should be 3 dots possibly that you need to click on. Or there should be a microphone somewhere that you need to click on. While she's trying to get her microphone on, Ms. Abden, would you like to address the court?
Yes, Your Honor. Thank you. My client is 41 years old. He's born in Georgia, lived here his whole life. He has strong ties to the community. He is a father to 7 children. The complaining witness and my client have 4 children together, all of which are minors. He is the primary breadwinner, and he is responsible for drop off at school for the 7-year-old child that they share. He is gainfully employed. He works for Cash for Junk Cars ATL, and he buys junk cars and tows them. And as I've stated, he is the primary breadwinner, Your Honor. So the longer he does remain in jail, the less likely it is that he will have a job. He does firmly deny these allegations. And it is my understanding as well that there is an open case where the complaining witness is also the complaining witness in that case. I did look it up. It does look like he is enrolled already in a domestic violence pretrial diversion program in that case, and the 2 of them were ordered to have no further violent contact. This incident did occur about 2 months ago. As I've stated, my client firmly denies these allegations. We are requesting no further violent contact, so they can continue raising their kids together and work this out amongst themselves. I understand the state and the court's concern of the violent criminal history. As it relates to the complaining witness, Your Honor, he did tell me that she is currently struggling with some substance abuse issues. He was not home at the time of this incident, and as I've stated, he firmly denies these allegations. Ever since he's been enrolled in the diversion program, he's really made substantial changes, and he is requesting, Your Honor, to take that into consideration. And so I am requesting a signature bond and no further violent contact. And if Your Honor is not inclined, a significantly lower bond than the $5,000 that was requested in preset, as he cannot afford that at this time.
Ms. Tooks, let's see, can you hear me now?
Yes, sir.
Okay, can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. What would you like to tell me?
I do remember that incident. Again, me and Kevin have been married for 13 years. I'm not sure where they got the boyfriend and girlfriend from. We've been married for 13 years. Of course, you know, everybody goes through something. I never told them that we have not gotten into it since last year. The lady asked me about the last incident from this year. We have not gotten into it since then. We've been talking about going to counseling, which I was going to try to do through my job. They offer so many sessions to me at my job with Fulton County Schools. And he's been good. He has not had a drink in about 2 weeks or so. So, I mean, everything's been pretty good.
Okay, you're not afraid of him?
No, sir, I'm not.
You want him back in the household?
If he can.
Okay, and it's my understanding that he's already enrolled in a domestic violence class. Is that your understanding?
Yes, I thought it was finished, but yes, I did know he was from the case from last year.
Okay.
Your Honor, and I just want to put it on record, considering that he was in a family violence intervention program and this incident happened while he was in the family violence intervention program, that is problematic, Your Honor.
Your Honor, these are allegations at this time. We are just discussing bond today. This is not his sentencing. We're just trying to ensure that he returns to court and, you know, that the public and the complaining witness is safe. Based on what you've heard, she is seeking no further violent contact. The incident allegedly did occur in, I guess it was July, and so the information I got from their court's website is that the completion of the program was August 25th. However, the case is still open. I'm not really sure why. And so as you've heard, they haven't had any instances of violence since he'd enrolled in this program. They're talking about going to therapy. They are working things out. And so I am still asking for a signature bond, Your Honor, and no further violent contact.
Okay. We had 3,000 through pretrial per the judge. No further violent contact with Ms. Tooks. No drugs, alcohol, or weapons while out on bond. So if it hasn't been ordered before, and I understand that you're doing well with not drinking, Mr. Beasley, if you do drink, then you're going to be in violation of this bond order, and it's going to be subject to being revoked. So you're not to have any alcohol while you're on bond. You understand me, sir?
Yes, sir.
All right. Good luck to you. Mr. Beasley, you also, Ms. Tooks.
I knew something wrong with her.
You're welcome.
You got a 3,000 SOB through pretrial for him, correct, Judge?
That's correct.
Okay, our last one, Judge, is gonna be position 10, Mr. Minor. Don't take
Good afternoon, Mr. Minor. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Minor, you've been charged in case 23 CR 0058886F with criminal trespass. Is there a history, Mr. Howard?
This is fourth arrest. I think all of them from this year. Last arrest was June. Trespass, damage to property. It's 23 CP 219783. On probation for criminal trespass and loitering. It's 23 CR 001-095J. On another probation for trespass, 23 CR 002-886C. That's it.
Yes, Ms. Sorry.
Your Honor, this incident took place at 1953 Valley Ridge Drive in Atlanta. The defendant was evicted from this location in January of this year. And as you've heard from pretrial, he has been previously charged with a felony for the criminal damage to property at this very same incident location. This defendant was found yesterday. He was found in the home. He climbed through a window, and officers responded and saw him in the closet. I would also like to point out in this case, the same incident location from the June of 2023 case, the defendant was given a $10,000 surety bond, and then his attorney requested a lower bond, and then that's when he was given a UJR by Chief Glanville. Yet here he is today with another violation by returning to this very same incident location. So, Your Honor, the state is requesting a $2,000 surety bond, a stay away, no contact with the victim, and I'll grab her name in 1 second, no drugs, alcohol, or weapons. And we did speak with the victim, who stated that the defendant left a box at this location, so she would consent to a one-time law enforcement escort.
Ms. Kim?
Yes, Your Honor. I would like to request for a signature on bond, Your Honor. Apparently, he is residentially challenged as he was evicted, and he believes he owns this place. I think they should have probably a civil action going on for true ownership. And yet, as of now, my client is qualified for public defender's services because of his unemployment. From February 26 to September 13, he was in jail for more than 107 days. So that because of the incarceration, he was not able to work. He was not able to keep the job. He recently lost her only daughter, who was 3 years old. So CL is her initial, and he's been going through a very, very difficult time. We would like to request for a signature on bond. Thanks.
And Judge, the victim, the owner in this case, her name is Annette Roberson. She is the defendant's aunt. But as I've stated, he was evicted from this property back in January, and he does have an open felony with the same incident location.
He is still presumed to be innocent, Your Honor.
It'll be $1,000 good bond. No further contact with Ms. Roberson. Stay away from the Valley Ridge Drive address. No drugs, alcohol, weapons while out on bond. Ms. Kim, if you'll have a social worker visit him, and if you'll report back at the SAP if he's still in custody at that time. I'm concerned that it's not only one, but it's multiple times that he allegedly keeps going back to this address. And I'm not sure why, but if that's because of housing, then I'm certainly inclined to help him out in that way. If there's some other reason that he keeps allegedly going back, then he needs to not go back there because he's been ordered time and time again not to go back to that location. So for the time being, it'll be $1,000 good bond.
Thank you.
Good luck to you, Mr. Minor. Okay, looks like we have a number of waivers.
Yes, I was just getting ready to tell you, Judge.
Okay, you can go ahead and tell me.
Or did you already know, Judge?
I think I know 14, 18, and 3, right?
Yeah, position 3, waive the appearance. For position 9, Mr. King, we are currently in the process of looking for him throughout the jail. Mr. King.
Okay, so if you find him, we can take him, but if not, we'll reset him for tomorrow. If that's
And then yes, position 14, waive of appearance. And 18.
right. Okay, all right.
Thank you.
Thank you. So let's leave position 3 until last, given that it's an MH. Position 14. Mr. Sherrod Thomas, does he have a history, Mr. Howard?
43 total. Last arrest was in May, possession of marijuana. He has an open case out of the city. On probation, possession of cocaine. 2023 probation, 2022 failure to appear, 2021 probation. 2020 reckless conduct, simple assault. 2018 probation and a 2017 failure to appear. I stopped there.
Okay, Ms. Jackson?
Yes, Your Honor. This incident took place on October the 1st at 50 Upper Alabama Street. Police were dispatched there regarding a criminal trespass. The underground security officer approached the officer stating that the defendant had trespassed before and continues to return to the location. The security officer said that the defendant is a problem every time he returns to the location, and he was able to show the officers the trespass warning that was issued against the defendant on September the 8th. So we'd be asking for $1,000 SOB through the jail and a stay away from 50 Upper Alabama Street. Nothing further, Your Honor.
Any objection, any of that, Ms. Kim? No, I'm sorry.
Judge, what was the bond?
$1,000 SOB through the jail.
I apologize. I didn't realize it was muted. No objection, Your Honor.
Okay.
That was position 14.
Yes, that was position 14.
Thank you.
Position 8, Winder, is there a history?
Number 18, 13 total. Last arrest was in January, probation. He got an open possession of a firearm by convicted felon. Failure to signal lane change. That's 22 CP 213068. On probation, out of Fulton, it's a lot of counts of entering auto. It's either, I want to say it's 34 or 50 of them, or something
It's
like
50.
that. Yeah, it's a lot. On probation in the cab for burglary. Got probation violations from 2021 and 2023. Actually, it's 70 counts of entering auto. Just thought about that. Yeah, that's it.
Okay, Ms. Lemony?
Yes, Your Honor. This incident happened September 5th of this year at 2406 Martin Luther King Drive. Officers were patrolling the area due to its high level of using and selling drugs. They made contact with the defendant when I think it was a group of individuals there. They made contact with the defendant. 2 individuals went into a car and then 2 others fled. As they made contact with the defendant, he darted into incoming traffic, and in which he was hit by one of the vehicles that was in the traffic. And then he reached the sidewalk area. As he was passing through traffic, he was seen with a handgun with an extended magazine in his waistband, in which he was trying to uphold in his hands. The officers lost him for a second. considering that he was just darting up and down. After he was relocated, the firearm which was in his possession was not found on his person. He ran into the side of the building, showing disregard for his own well-being, considering that he had just got hit by a car. He slowed from running, and then he ended up running into the officer's car, in which he was captured and placed into handcuffs and taken into custody. He was currently on home detention under Fulton County with an ankle monitor to his leg, considering that he is a convicted felon with 71 cycles of arrest. And the firearm that was in his possession that officers did see was no longer there. He threw it somewhere and they haven't been able to locate it. Bond is currently, for count 1, bond is currently at $1,500, count 2, $1,000, count 3, $2,500, count 4, $2,500, all surety. The state is asking to change counts 3 and 4 to $15,000 each, considering that he did have an extended magazine and a gun in his possession when he was on probation and asked not to have a gun in his possession. And then counts 1 and 2 to change those to 500 surety, Your Honor. Based from my understanding, you've heard his criminal cycles and you've heard some of the history. So the state is asking that you take that into consideration, Your Honor.
What is the reckless conduct?
That's darting into incoming traffic and throwing the gun, the magazine, the gun with the extended magazine nearby.
And what's the tampering with evidence?
Removing the gun, considering that he was on probation and he wasn't allowed to have guns on his person. And I guess he did not want to be caught with the gun. So he threw it in his flight as he fled from the officers.
And he wasn't charged with any gun violations because you didn't find a gun. Is that right?
To my understanding, it was originally a felony, but it was dumbed down to misdemeanor, Your Honor.
Okay, because you didn't find the gun. Is that right?
Excuse me, Judge.
Yes, Mr. Howard.
Ms. Kemp, I believe we received a consent order from Ms. Falk in relation to this case, where she was recommending a total $6,000 signature bond on this case. Was that not communicated to you, Ms.?
Yes, it was communicated. It was because on October.
I mean, to the prosecutor, to Ms. Nimini or Mr. Walker.
Also, well, yesterday at 4:41 p.m., the possession of firearm by convicted felon was basically dismissed by the judge because of lack of probable cause. So because of that, the remaining things, which was all those charges were assuming that he had a gun, but that didn't have any probable cause. Everything else is also a Riverside issue. He has been here in jail ever since from September 7th. So that's
well, it's Ms. Kim, I don't mean to cut you off, but if there's a consent already, that's
Yes.
all we need to address. So
That's what
Mr. Walker, are you with me?
And Ms. Nimini, I can forward you the email from Ms. Falk, and maybe you can look at it or reach out to her.
Okay, thank you.
Okay, so if there is a consent, Mr. Howard, can you all get us that consent?
Yes, Judge. I'm gonna forward that over to the state now.
Okay, yeah, and it's it's Miss Champion that's with me today.
I'm sorry, I'm here. What case?
This is position number 18. Mr. Howard was just informing me that he and Ms. Falk entered a consent on this matter as far as bond is concerned, and I was just wondering if you know anything about that.
That's correct.
All right, so that bond sent over to Ms. Champion, then we'll get it signed and entered.
Yeah, Ms. Walker, I just forwarded it to you and Ms. Nimini.
I was on the initial email. That's correct. I recall.
Okay.
Okay, all right, very good. Thank you. I appreciate that, Mr. Howard.
No problem.
On the final case, Mr. Brown, do we need, just to go off of YouTube, or do we need to go into a breakout room?
So what's the bond amount? What's
Yeah,
the,
that's.
Okay, could you put the bond amount on the record, Mr. Howard?
Oh, I apologize. I can do it. Oh, go ahead, please.
Oh, you talking to me, this, Ms. Howard, Judge? I'm sorry,
Either
my-
one, whoever wants to put the bond amount on the record.
$6,000, Your Honor.
I think it was
Signature-
1,500 on each charge, Judge, if I'm not mistaken. Let me just look at it. Yes, 1,500 per charge for the obstruction, failure to use crosswalk, reckless conduct, and tampering.
Okay,
SOB, Judge.
You said it's XOB jail?
Yes.
all right. And my question was in regard to position number 3, Mr. Brown. Do we need to just go off YouTube, or do we need to go into a breakout room?
Your Honor, I would prefer a breakout room because it is MH, but we can go off the recording as well.
Whichever you prefer, it's fine with me. So,
A breakout room, please, Your Honor.
okay.
you want the history first?
You've told me that there were 100. Is that
120.
right? You want to give me the last 10 years?
No, I didn't make notes of the last 10. So he got 122 total. Last arrest was in June for battery. He has an open entering auto in Superior Court, 19 SC 165173. The open June case is 23 CR 004 041. And the open trespass 23 CR 003 206F. It's probably like 20 plus arrests in the last 10 years.
Hey, I'm sorry to cut in at the end. We could send it to Pat. Is that still not the plan of action? He's not suitable?
No,
Okay, understood.
thank you.
Okay, so who needs to be in the breakout room? Mr.
I'll
Howard,
do that.
Ms. Abden, Mr. Walker, Ms. Kim.
Yes, thank you.
Did you get that, Mr. Jordan?
I'm working on it now, too.
Oh, okay, just wanted to make sure. Thank you.
Does anyone else need to go in the breakout room?
Yes, yes, Judge, what's the bond for position 3, Mr. Brown, Rico?
It's a $2,000 signature bond through the jail.
1,000 on each.
Thank you.
Okay, I believe that concludes the calendar for this afternoon. Ms. Champion, when you're ready, we can go over the calendar.
And then for Mr. King, we were still not able to find him.
Okay, so he'll be reset for tomorrow.
But yesterday he was actually at downtown court, so
Okay,
makes a difference.
Well, I would like to avoid any potential Riverside issues. Yesterday, he had court downtown. We don't know what happened to him today.
Yeah, we're still looking. They're still in the process of looking for him.
Okay. And if I said Riverside, I think my original recommendation was a signature bond anyway. So I don't know if that makes a
Right,
difference.
right. He was a pad referral, so we hoping he can come so they can interview him.
Right. He was referred to PAD. So
What you say, Ms. Webb?
so he was you're right, he was referred to PAD. So as soon as we could find him.
Yeah,
He'll get a signature bond.
yeah, not like one way or the other. Right.
okay, if nothing else, Ms. Champion?
Yes, position number 1 is a $3,000 pretrial bond per judge reset for the notice. Position number 2 is a total of a $2,000 good bond reset SAP 1017. Position number 3 is a total of a $2,000 sign-on bond through the jail reset for the notice. Position number 4 is a total of a $5,000 sign-on bond through the jail reset for the notice. Position number 5 is a $3,000 good bond reset SAP 1017. Position number 6 is a total of a $2,500 sign-on bond through the jail reset for the notice. Position number 7 is a total of a $2,000 sign-on bond through the jail reset for the notice. Position number 8 is a total of a $2,000 good bond reset SAP 1017. Position number 9 will be reset to the C on 10-4. Position number 10 is a $1,000 good bond reset SAP 1017. Position number 11 is a total of a $5,000 pretrial bond per judge reset further notice. Position number 12 is a total of a $4,000 good bond reset to the 10-5 mental health court. Position number 13 is a total of a $5,000 good bond reset SAP 1017. Position number 14 is a total of a $1,000 SOB through the jail reset further notice. Position number 15 is a $1,000 SOB through the jail reset further notice. Position number 16 is a $2,000 good bond reset SAP 1017. Position number 17 is a total of a $1,000 SOB through the jail reset further notice. And position number 18 is a total of a $6,000 SOB through the jail reset further notice. Any questions?
Yes, may I have the conditions for position 11, please?
Stay away from Cairo Street, no further contact with Bennett, no drugs, alcohol, or weapons.
Thank you.
Anything else? All right, thank you all. You have a good rest of your day. We'll see you next time.
Thank you, Judge.
Thank you, Your Honor.